gentlemen, I'm going to start quite soon, and the reason for that is we all need to listen to Denise later, and we're going to run out of time for the question bit and Denise and me if I don't get started. Now, I'm actually going to focus on issues relating to the British Constitution. And the reason I'm going to talk about the British Constitution is that explains why things have got so bad and why it's actually how we can get things changed. Obviously, people are aware of the individual cases that have been referred to earlier. Adding to it, for instance, on the issue of solicitors, a social worker who was unhappy with the way the system operated came to see me about 3 or 4 years ago, knowing of my concerns about the system, and he explained how he, as a social worker in Birmingham, used to sit down with solicitors, the parents' solicitors, and work out how to make sure the parents lost their case. Alright, so that was a solicitor, a social worker telling me exactly what had gone on. Now, obviously, if you are somebody subject to a conflict of interest, that is, you work both for the local authority and for other people, if you fight the local authority too hard, they can be upset about that. And so there is a pressure. So people like Brendan, for instance, who don't work for the local authority, he does not take the local authority's shilling, is not subject to that conflict of interest. Now, it is argued by the Solicitors Regulatory Authority that there is no conflict of interest when you're paid by somebody you're fighting. And admittedly, there was a solicitor in Birmingham who said, well, I shouldn't really be in on this case because the day before I was working with the local authority. But there really is a conflict of interest when you're fighting your paymaster. And that is one of the factors. On the issue of experts, there are very good experts. Before today, the highest price I'd heard of was 28,000. We've now managed to cap that with 37,500. There are very good experts. There are also experts that are not that good. One of the better ones came to see me a few months ago and explained how at times she would write a report and the solicitors would say the local authority won't be very pleased with that report. There is a thing called the repeat player effect, which has been analysed in the USA, which looks that, and this was looking actually at people who used arbitration for employment proceedings, and they found that people who use the system more often tended to get better results from it than those who don't. So the difficulty for experts is if they upset the local authority will resist their appointment. So it's not that they won't get paid for that particular transaction, but they may not find that they're instructed again in the future. So you encounter that difficulty. And when you've seen care proceedings and worked out what's entailed, and there's vast piles of paperwork, much of which is repeats of other pieces of paperwork, and at the centre of the care proceedings are some assertions by so-called experts, such as, in Birmingham, a parenting assessor who deemed that it was too risky to put a baby on a mat by another baby, and that you should feed babies on demand, not on demand, by routine rather than not on demand. And as a consequence of those assessments, and I have spoken about these in Parliament, a mother was deemed an unfit mother and her child was not placed with her and was put up for adoption because she took the major risk of putting her baby on a mat with another baby. Now, the Appledore Centre that did this assessment is a place where a baby died from a mother getting drunk and rolling over on her baby in bed. Now, you would say, would you not, that if a baby is being looked at a mother in an assessment centre, they might be concerned that the mother's getting very drunk and rolling on a baby in bed. But the argument was put forward that they wanted to know how much money she spent on alcohol for the assessment, so they weren't really too worried about her getting drunk because their objective was to assess the situation, not to protect the child. So you have all of these cases, and I'm not going to try and go into lots of individual cases, but you have underlying this a problem that there are professional liars. There are people who go around and lie for money, and that the judges have to rely to some extent on those. Now, they are not all like that. In one room you might have some excellent professionals doing a really good job, and in another room you'll have twaddle being spoken and things completely haywire. Play therapists being used to say that children should be adopted. You know, whether play therapists should be considered to be adequately experienced to make such decisions is an interesting question we could perhaps address to somebody with some knowledge. But I don't think myself that a play therapist is the best person to advise whether a child should be adopted or not. So in one room you have complete twaddle going on. And the difficulty you've got is that that twaddle is unaccountable. It is not made aware to the public. So when we have care proceedings talked about, we have Peter Connolly, baby P, who died, and that's, a lot of people understand that. And you have Victoria Climbier, a lot of people understand that. But actually care proceedings are not normally about that. That's not emotional abuse, that's not shouting at the children. Most care proceedings are nothing like that. Things like sort of postnatal depression, puerperal psychosis, which does give rise to a child protection risk. But taking the baby off a mother with serious postnatal depression, placing the baby on twin tracking with adoptive parents, is not going to help with the depression and is likely to lead to a self-justifying prophecy. So we have a system that's going very badly wrong. It affects a lot of people. It affects people who are weak politically. That is, they often don't have a lot of money, so we have difficulty. People I have at times, I've paid the travel costs of people on benefits to get to the appeal court, because otherwise they couldn't go to court. I can't promise to do that all the time, but I've done it on a couple of occasions. And you envisage the legal system that we have, and the legal system we have depends on the appellate system and the appeal courts in London in the main. If you can't have appeals, you can't make sure that the appeal system works. So we have a situation more recently where the local authority in Guardian tried to charge the solicitors for the parent for the costs of the appeal. That is, the solicitors, not legal aid, but the solicitors. That is an attempt to stop appeals. I am pleased that they didn't succeed, but that is an attempt to stop appeals. We have 2 cases in Birmingham. One of the things I do is I table early day motions, and some of them only ever get 1 signature, because I'm not intending to get lots of signatures. I'm just intending to put things down on the record that potentially otherwise would be contempt of court. There are 2 cases in Birmingham where we've got no judgment. All right? We all know a sort of story about not having judgment. If you wish to appeal a legal case, you have to explain why the judge in the court of first instance is plainly wrong. For you to explain why the judge is plainly wrong, you need a copy of the judge's reasons, viz. The judgment, and without that you can't appeal. And we have 2 cases in Birmingham, very recently, and I've tabled a motion about them in Parliament, where on the file there was no judgment. We have not been able to get the judgment. We've actually now gone to transcription people, and the tapes have got lost already. Right? So we had a judgment on the 26th, an order given on the 26th of September, and there's still no judgment. You're supposed to appeal within 21 days. Of course, you can't appeal without that. And that's a clear failure of the system. It's not that difficult. Transcribing the judgment costs about £100. If your average legal case in care proceedings is £25,000, which is about a fair assessment, to actually get a judgment and make it possible for the lower court to be held to account is not that difficult. We had a case, which was DF Children, in fact, which I can't name who DF Children's about, but somebody's in the room. And we appealed on the basis of there being no judgment. Nothing happened, because you can appeal on the basis no reasons given. And then suddenly got ambushed in the Court of Appeal with a judgment that turned up. Jerry phoned me up with great enthusiasm, we've won the appeal. No judgment comes from the Court of Appeal. Right? About 6-7 weeks later we get, you've lost the appeal from the Court of Appeal. So I write off to the court and I say, can we listen to the tape recording of the hearing in the Court of Appeal? Because you're supposed to be able to listen to those, I thought, at the time. Nothing happened. So I wrote to the Minister saying, I've written to the court and said, can I have a listen to the hearing? of the transcript in the Court of Appeal. And I get a letter from the Minister and from the court saying, no, we've changed the rules and you can't listen. And if you want to know why we've changed the rules, you need to write to the Judicial Executive Board office. I think it's TM 117. But I may not be right on that. But it is the Judicial Executive Board. So I wrote to the Judicial Executive Board, and I've not had a response. But, in accordance with the Freedom of Information, I have to wait 20 working days before I can report them to the Information Commissioner. Those 20 working days end on Monday. So let's see where that one goes. The Judicial Executive Board is a committee including the Lord Chief Justice and all the various senior judges, and it does not produce any minutes of its meetings, and it is not effectively explaining what it's doing. I wrote to the government and I said, what's your views on this? They said, that's up to the judges. Now this brings me to the constitutional point, and we have a standard constitutional model of separation of powers with an executive, historically the king, a legislature and a judiciary. And it is important to maintain separation of powers, there's no question about that. The problem with separation of powers, and we have what's called a weak parliament model. Now, as an aside, there was a meeting of the Procedure Select Committee, which is actually tape recorded. It hasn't yet been published in the transcript. And anyone who's interested in parliamentary accountability should listen to the recording, which you can find linked from my weblog, johnhemming.blogspot.com. Because you have there an example of a committee laughing at a minister when they talk twaddle. Because the minister, this is the Department of Education, which covers this area as well, and the minister was trying to explain how they try to give full and accurate answers to written questions, when in fact the written question they'd answered, the question that was asked was, it was actually asked by the ex-minister what youth projects had each minister visited over the previous 2 years, and the answer given late was they visited lots of places. That's it's a slightly longer answer than that, but they didn't name any places that were visited. And when the minister tried to say, well, we took a long time to answer the question because we had to give a very full answer with lots of accurate details. But if you want to listen to MPs laughing at a minister, you probably don't get that many examples. This is not politically partisan, because the whole committee laughed at the minister. But sadly, it wasn't on video, but it is on audio, and if you want to listen to it, if you look at my weblog, you'll find a link to it. So you have the separation of powers, and you have the executive, which is the government, and then you have the legislature, which has powers that it doesn't use. And Christopher Book is right, that it's actually, in a sense, Parliament's failure that we're not making progress on this. And then you have the judiciary. And the government are not allowed to criticise judges. That doesn't stop them at times, when they feel like it. But they're not supposed to criticise judges. And when you write off about an individual case in the courts, the response of the government will generally be, that's up to the courts, that's not our decision. I, as a backbench member of Parliament, am allowed to criticise judges. And one of the advantages of not being a minister is that I can table what I want, say what I want, within the limits of the rule of sub judice, which means that if a case is to be determined in the courts, it cannot appear in parliamentary proceedings. But it does allow me to table early day motions about things that are going wrong in the system, and use that as a process whereby it's not trapped by any of the contempt rules, which you'll find it interesting. I break lots of court orders in Parliament, but it's only the ones everybody knows about that they complain about. The ones that nobody knows about, nobody ever complains because they don't want to highlight the fact that it goes on, which is interesting in itself. So one of the problems is when in this country people want something to change, they contact their MP who writes to the minister. And if it's something about health service funding or something like that, that's a sensible process because the minister's in a position to decide what's going to happen on the funding. But in practice, when the problem is in the judiciary as it is, and it's quite obvious that it's in the judicial estate of the Constitution, if we look at this issue of accountability and the fact that the decisions are based on opinion, the opinion is not accountable, and if you can't have a second opinion, there's no way you can get it right. And you can compare and contrast two European Court of Human Rights cases. One is X v Croatia, and the other one's RP versus the United Kingdom. Now, RP versus the United Kingdom is a case where straight the way through to the European Court of Human Rights, a mother was deemed to be someone with significant learning difficulties who did not have the mental capacity to instruct a solicitor. The only problem with that is, in fact, she doesn't have significant learning difficulties and does have the mental capacity to instruct a solicitor. I can say that not just because I've met her, but also because I have expert reports that say that, and her GP that says that. So this case has managed to go on the basis of a single expert in the lower court all the way through the Court of Appeal where they slagged me off, the House of Lords, to the European Court of Human Rights, and I've drafted some papers to go to the Grand Chamber, but we don't know whether it'll go there, without a second opinion. Now that's not really an appeals system, because you're not getting anyone else looking at it. You're just getting another judge look at the original consideration, and it just goes all the way through the system. So the intellectual reliability, the question I had Graham Stewart, who's the chairman of the Education Select Committee, say, what questions should you ask the judges? Should he ask the judges, because he's going to see the judges? And I said one of them is, what confidence can you have in the intellectual integrity of the opinion that you see? The answer is none, because there is no challenge to it. It's all about CVs. And when you have a good expert, often my degree is in physics, especially in atomic and nuclear and theoretical physics. And you can look at something, you can say, well, that seems to hold together, it doesn't seem to be complete twaddle. But I don't have the expertise to necessarily do as a good job as a colleague over there. So you have this problem with intellectual integrity. Now, so the problem is in the judicial estate of the Constitution. The procedures are wrong. Parliament can change the procedures. Government can't. The government could have the procedures changed through proposing something in Parliament, but it's Parliament that sets that. And what happens is people write to the MP, who writes to the minister, who then passes it to the judges, and nothing happens. And that has gone on for a long, long time. Now, we can get it changed, but what we actually need to do is create a public demand for Parliament to act. To create a public demand for Parliament to act actually requires highlighting of enough cases. And to be fair, the Ireland report from earlier, what I would say about the Ireland report is there's two things. It is academically approved, but it is also an authorised report. And one of the problems we have with family court proceedings that I tried to change earlier this year in the private members bill that still may get changed is you can have academics review the proceedings in the family court, but only if it's authorised. And only one project ever has been authorised, as far as I can tell, which is the one that you were involved in. And that one found that most of the stuff was rubbish, but not all of it, which is more than I thought. I thought a lot was rubbish, not that the majority was rubbish, which is interesting. So where we have is this problem, and we do need to be very careful. People have this tendency to write to the Prime Minister about the problem, thinking the Prime Minister is in any position to do anything about it. Our Constitution does not allow the Prime Minister to do anything. So the Prime Minister will not achieve anything. And we actually need to focus on Parliament. We need to focus, Parliament could establish a parliamentary committee particularly to look at it, but it needs the demand from outside Parliament, because Parliament does respond to the citizens. When there's a big fuss about something, Parliament will act. The Education Select Committee needs to be willing to look at individual cases. I keep on making that point to them. The Justice Select Committee needs to be willing to look at individual cases. And it's that sort of process. I'm just seeing where I'm at on timing-wise, because I've got, I think, another...
Just Vicky, you have to leave.
Sorry?
Vicky has to leave.
I've got to tag on, John.
So you've got to go. Do you want to talk? Yeah, you're going to just go.
I've got to go,
Go.
yeah.
Bye-bye, Vicky.
If I don't go home, I get put back in the prison.
Yeah. All right. Anyway, so the reason why things don't change is people are used to the traditional model of achieving change, which is that the Prime Minister achieves change. In this instance, the government is not in a position. One of the great problems you have, you take the Family Justice Review, which looked at the family justice system. What did they do? They went to a lot of people who run the system and say, how good a job are you doing? And they said, we're doing quite a good job. In fact, they wrote it right at the start of the report, saying, everyone in the system is perfect, something like that. There's this standard phrase you get which pretends that everyone's perfect, when we know a lot of people are not. including those social workers who employ hitmen, which is, to be well, was only one social worker, although we believe that somebody was firebombed by a social worker as well. Not trying to identify any pictures anyway. However, the reality about it is that you won't get the change through the government. You'll get the change through Parliament. Interestingly, at a pan-European level, you have parliamentary bodies as well. And people often don't know there's a difference between the Council of Europe and the European Council. All right? The Council of Europe is a much larger body. And there was recently a motion that went through the Parliamentary Assembly for the Council of Europe, which came out of an inquiry that was created initially by myself and Paul Rowan, who is MP for Rochdale. Sadly, he lost his seat in the general election, but that inquiry still went under the Christopher Chope. And in fact, a motion which was critical of the UK went through the Parliamentary Assembly. Now that's good, but it's this Parliament. This Parliament, for instance, can remove judges if it feels like it. It's not generally done. It's under the Act of Settlement. I think that's 1701, but it may be 1707. 1701, right. So this Parliament can remove judges. I don't think we'll need to go that far, but I do think we need to highlight the problems in the process, and that there is a clear problem that the judiciary are not doing their job properly, which is the nub of the issue. But there are interesting things going on. In fact, in September, I sat down and worked on papers for 2 appeals, both of which were allowed. And one of them was relating to a Slovak family, where the Slovak government were also getting involved. And that one's had a lot of press. But in fact, there was a situation yesterday and the day before where a Slovak baby has disappeared from the UK. And when the the Slovak Republic's equivalent to the official solicitor left the country yesterday, she was quizzed by the police on the way whether she knew where this baby had gone, which is an interesting one. But it just shows this, when you have, as you have, we've got the media downstairs. Now, I'm in touch with Polish cases and lots of other cases as well. And I think what we have managed to do, we've managed to get the Commissioner for Human Rights in the Council of Europe to agree to look at the system in the UK, and that's good in itself. Although, again, all of these things are about taking individual cases and highlighting what's wrong with the cases. What we've done with Justice for Families, we've focused on particular cases to highlight the injustice, which makes, we're not doing a mass of situations, but we're trying to progress things through. And it is very, very difficult to achieve that. But I do think progress is being made. Jerry's been working in this area for ages, and the judges now respond differently. Even this year, there's been a shift in the response. And it's because they know they're being looked at. And also, they can't get away with just covering everything up all the time. So we've managed to reveal certain things. There's a particular early day motion, which I shall read out, which I think is quite an important early day motion. Where, again, these things, because it's in Parliament, you get the usual thing, because it's in Parliament, it can be talked of outside Parliament. And this one says, this House notes that the failure of the appeal of the parents against the adoption of their children in the case EWCA Civ 1487 further notes that the reason the children were taken into care was an allegation that one child had a fractured skull. Further notes there's evidence from 2007 that indicates that the child's skull was not fractured and instead fissures, but that this evidence was not given to the parents until after the finding of fact hearing. Further notes that the second appeal failed because Mumby rejected an appeal on 23rd of September 2011 against the finding of facts, in part because new evidence was not provided to the court. Further notes that this rejection was emailed in a scan of the judgment to the parents at 12:18 p.m. on the 23rd of September 2011. Further notes that the mother has been given a deadline for providing the evidence of 4 p.m. on 23rd of September 2011 and provided that new evidence at 11:30 a.m. on 23rd of September 2011. Further notes that it is clear that the evidence given to the administration at 11:30 a.m. was not provided to the judge when the decision was made, and recognises with sadness that the failure of the court administration to provide the new evidence to the court for consideration on the 23rd of September 2011 has resulted in a miscarriage of justice. Now, that sort of process of highlighting individual cases through parliamentary motions is a good process when we can get all the paperwork together and it's not sub judice. And I admit that at times only one person signs these motions, but it's important to put them on the record, because then people outside Parliament can see what's going on. Similarly with parliamentary petitions. And there are complexities that the issue that and I would highlight there are lots of other MPs who are concerned about this, so you can very often find that your MP will assist in doing this sort of thing. And a lot of MPs do come and talk to me about the cases, and they talk about how to make progress on it. So, you know, it is a corrupt system. It's not completely corrupt. It's an unaccountable system where the patterns of accountability don't work. But we have made some progress in getting it fixed. We can make more progress, but with all of your work in making sure we highlight individual cases and get a public demand to get change.
Mr. Harry, can I tell you?
Yeah.
I know that the grandparents will never get the rights to kinship or whatever because of the finances, because we're free of charge and foster agencies will lose money, we know that. Can you find out from whoever why they will not give grandparents rights? We know, as I've just said.
Well, in practice, the issue about rights is to what extent you have enforceable rights. And in the case of the Slovak family, where we appealed that case, we appealed it on the basis of the child going to the grandmother. So, arguably, on that particular instance, it creates a precedent where grandparents are given rights, or great-grandparents, if we take in Phil's case. Progress is being made on that.
You know, Mr. Henry, sir, that's how much respect I have for you. I don't care what anybody thinks. Anyway, sir, I tell you this, that over 250 MPs know of my case. I have written to them. 5 replied.
Yeah,
and this goes back from Jack Straw and
basically, MPs are human beings, believe it or not. They need to sleep.
In some cases.
Yeah, they need to sleep.
In a coffin.
If you send an email to everybody, a lot of people will just delete it, including me, right? So simply because there's too much. You can't send. That's why you're supposed to go through your own member of parliament, because otherwise it overloads people. Now, I wasn't here this morning because I do my advice bureau, and I think it's very important to see everybody that turns up. And I'll see people who aren't my constituents if they come there. And people do come there from a long distance at times. But there are practicalities about the system, and one is this, that you can't, MPs can't deal with everything, which is why they have the standard response, what's your address, are you my constituent or not? And to be fair, approach the right way, a lot of them will make progress. And there are many MPs who are concerned about the system, but again, we're stuck in this constitutional problem where people are so used to the idea of the executive being all-powerful and the legislature not being. And that's why I emphasise that point about the Procedure Select Committee, because basically Parliament is, in constitutional sense, Parliament has the power. It's just that it tends to be passed on to the government because people think of it that way, when in fact it's the MPs that have the power. Phil?
It seems to me that only personalities go onto television. That's what it appears to me. Like the McCanns, for instance, they can get on television tomorrow.
It's not
Ordinary
what
people like us,
your
very difficult.
Yeah.
No, this is not the
Yeah, but
I got this speak from mine, Andrew Rosendale, apologising for not going.
Yes, but it's important to understand the process with private members' bills. I had been told, up until and including Thursday night, that the government were going to allow it to go into law in some form, and then it changed somewhere during the day. And around about noon. And I had members of the Conservative Whip's office saying, where's the bill gone? Because they thought it was going to go through. And it's the Whips, in the end, who didn't put it through because they got an instruction from the Ministry of Justice not to put it through. The bill hasn't completely failed as yet on the basis that the issues in it are still parts of discussion between me and ministers. So all sorts of things might happen there.
John,
5.
don't you think that if the family courts were governed by the same rules as the criminal courts, that most of these injustices could be.
I think, yeah, well the basic problem is the lack of accountability of proceedings, and it's not necessarily, you can't write about them in the newspapers, you can't write about them in academic journals. You have no intellectual integrity in the whole process.
The criminal courts are open.
The criminal courts are open, but the point is, when you have an open court, you have openness to regulatory processes. So you can't have in an open court somebody saying, oh, it's contempt of court to report that to the police or to the Health Professions Council or whatever it may be. You have the openness to academic scrutiny, which isn't necessarily whether it appears in the Sun or not, but whether it appears in a professional social work journal as, why are you doing that? That's completely mad. It won't do the children any good. We have a system that damages children, and it damages children putting them through the care system. Now, there is very solid evidence that every change of placement for a child is psychologically damaging. The first change of placement is take them off their children and put them in care. Now, at times you need to do that. And I accept your point that having a different standard of evidence also, because within the criminal courts you have a number of things. You have openness, which is the wider openness of public domain openness. The narrower openness is of regulatory and academic scrutiny. But you also have the different standard of proof, and I think there's an argument about that as well to be had. And the argument has to be had in the round and comparing international perspectives. But there's no question about it that the secrecy allows bad practice to fester. And if you look at the Irish situation, Ireland used to be quite a good place to go to. I think the HSE has decided now to be as harsh as possible on people who are turning up in order to save money, because Ireland is a bit short of money, and there's no doubt about it that the Irish authorities are not happy with the flow of people going there from England for the well, there's a sort of judicial conflict issue. So if you're going anywhere at the moment, I'd recommend the Slovak Republic. I'm not joking about that either. You know, we have very good contacts there. It is the Marisa Perisakova, who is the Slovak Republic's representative in the European Court of Human Rights, has been working with us to try and get these issues properly considered at the European level, Council of Europe, not EU. Am I done now?
Well, this goes back to what you were saying before, John. What's the Ireland's now cracking down. We decided to make an example of Stella McLeod. I don't know whether...
Well, not just Stella, but somebody else.
No, there's other people as well.
There's other people there deciding how to go.
I was going to make a point here. No one's ever mentioned the Every Child Matters national framework.
Yeah, but it's like all of these things. The government launched recently a charter for children leaving care, and the question was asked, how enforceable is this? And the answer was not at all.
I mean, what bothers me about that, one of the national indicators, is there in black and white, is to rescue children from low-income households. And I mentioned that in court. You could hear a pin drop. That is giving a licence to steal kids.
Well, interestingly, if you look at the stats, there are in fact figures on why children were taken into care that were adopted, and some of the children that were adopted because and were originally taken into care for being from a low-income household. There's only small numbers.
Well, I mean, it's there.
Well, it's this bedroom tax as well that's coming in. I've got a 3-bedroom house. I can't get a job at the moment. I'm going to have to pay for maybe £30 a week. How am I going to survive? Because if I move, they'll only give me a 1-bedroom place, and then they'll say, you can't have children, you've only got a 1-bedroom place.
Is it the problem with that framework?
Yeah, but you're right. You're talking about the framing. You're talking about something else. All of these things, we talk about the question of grandparents' rights, the question of how enforceable your rights are. If you've got rights that are not enforceable, they're not rights. They're just words. They don't mean anything.
Well, why doesn't somebody in Parliament do something about it? Because as I've said to most MPs, it could be your children growing up, and they could lose it. You could lose your grandchildren.
As I said, we had a case which went through and won on appeal based on the private life of a grandparent. So it's sort of progress is being made there. Sorry? Green papers are sort of consultation papers, so I wouldn't worry too much about them.
Just a minute with advice about the European Court of Human Rights.
Yeah.
Take my case. It was put in by some people from Parliament. The case was put into the European Court of Human Rights. My case. They held on to it for X amount of years and then wrote back and said it's too late to do anything about it.
Yeah.
You kept the money.
Yeah. But what I would say, I emphasise the point about the RP case, where a case goes all the way through the courts with only ever one expert. So, you know, if they'll allow that one to go through, I'm not too sure they're doing a very good job, to be honest.
Absolutely. So I'm just
Paul,
wanting
yeah.
other people to keep at it.
I'm going to be turfed off now because we must get the knees on. Paul?
Yeah, I think the vast majority of us are convinced there is definitely something wrong. There's an evil smell coming from the social services. We're convinced of that. We've heard from Mr. Booker, who is also convinced of it. It's easy for us to see it. What I would like to ask you is, what kind of groundswell do you have in talking to your colleagues in the House? Because I really feel that even though I respect you, and I think you're doing marvellous work, John, but without the groundswell of similar opinions that you have, we are feeling that we have no hope.
Influence Parliament from outside Parliament. I've had more
They don't want to know, sir.
You influence Parliament from outside Parliament from getting... Let Denise talk about it. She'll explain it all to you. But what I will finish on one point, which I had more comments from other MPs in Parliament recently about an article I wrote in the Mail on Sunday than about any speech I've said in Parliament.
John, just quickly.
Yeah.
As a grandparent, you know, I said playing when we
Yeah.
got back. I can't get anyone from social service to speak to me, deal with me, or anything. So who do I go to above that? Well, they won't. If I go down the office, I'll go there regularly. You know me. I'll fight my case. I'll just get the police called up.
Can I talk
Yes.
to you later? Because
Yeah.
obviously I need to go into details of your case, which it's only sensible that we just talk about it. But there should be some way. Are you in Ben Gummer's seat?
Dr. Dan
Ben Gummer's very good on these issues, you see. So let's talk about it later on. In fact, yeah.
Can I just quickly, someone just asked me, they asked to ask me what would someone do about a judge who refuses to grant a hearing 6 months after applying?
Well, I would actually appeal on the directions, because there has to be something there. Jerry, yeah? Was Julie, when Tim...
Julie's just at the press.
Something crazy. I was stuck out in 2006.
Yeah.
I've had people, I found myself on the computer, I've had people out or out of work, and the one wouldn't take him off, so I've removed for his friend.
I think doing individual cases and what to do about your case in a public meeting isn't... I don't mind, I'm not rushing away at the end. I'd like to listen to Denise, but let's move on to Denise now, because quite happy that we have a case for process.